We will go on the record in the matter 24 CF 169.
Here we go. Folks, Jennifer R.S. is facing some serious charges. A plea and sentencing hearing is no joke. But pay attention because what looks like a felony hammer might just turn into a deal with an escape hatch.
State of Wisconsin versus Jennifer Rawls. State appears through Assistant District Attorney, District Attorney Kevin Schmidt in person. We have Ryan Reed, Defense Counsel, in person, as is Ms. Rawls. Set today for a plea and sentencing. Parties have reached an agreement. Mr. Reed, can you please recite the agreement for the record?
Thank you, Your Honor.
Yes. The length of it.
14 years?
Yep.
8 months?
A little bit, yeah, 8 months.
$18,800 in restitution. That's huge. And here's the catch. As long as Jennifer pays $500 a month, she can dodge a felony conviction. Think of it as a pay-to-avoid prison plan. But miss one payment and boom, felony locked in.
Total of $87,850.94 stipulated restitution.
It's actually 88,000. It's just that she has 1,000 posts.
I know that. I see that. Okay. And
Yep.
monthly payments of $500. Yep.
So it's the plea to that one charge as is, and then we amend into theft by employees. We do the DJOC on the felony theft, and then convictions on the misdemeanors costs. On the felony, that's the payment plan is described in there. It's $500 a month. It's got a $150 admin fee. It also alternatively lasts until she pays it back, meaning if she can do larger payments, she can get off of it sooner, which is the incentivization.
So she's pleading to the charge as.
So basically, she's swapping one giant felony for two smaller misdemeanors. It's like trading one huge thunderstorm for two steady drizzles. Not great, but way better than prison time.
Charged, and you're adding to misdemeanor theft?
Yes.
Yeah.
So essentially, she's avoiding the felony if she does pay it back over this long period, and no matter what, she's being convicted of 2 misdemeanors.
All right. But with regards to the misdemeanors, what is the agreement?
The agreement on that would be costs. She doesn't have any AODA issues or something like that to give DOC to deal with, essentially.
Ms. Rawls, is that the agreement that you've reached? Yes. Formal motion to amend to add 2 misdemeanor thefts.
So added.
So it's under $5,000, correct? I believe it.
It's under.
I think they've changed it so many times. Yeah, she's pleading guilty to the charge.
It's under 2,500.
Under 25. We're adding 2 misdemeanors. What statute do you have that?
Yes, it's just the misdemeanor theft statute. So the penalty provision is 943.23a, and then otherwise the actual statute of the theft is the same as this one, which is 943.20 sub 1 sub b. Oh yeah, I said too fast. Sorry.
Wait.
Statute's the same as the original offense in terms of the charge, which is 943.20 sub 1 sub b. Penalty provision is where it differs. That is 943.20 sub 3 sub a, which is under 2,500.
You're simply going to amend on the record. You're not going to do an amended information.
Notice how the judge insists on written documentation. That's because courtroom deals can get messy if only spoken. Paper trails matter. One missing form can blow up an entire conviction years later.
Court, before I do the amended information after the hearing, I can do that.
I'm going to say in cases like this, Mr. Schmidt, I'd like that because I've seen a Washburn case that I'm on blow up because they just did it on the record and it got all messed up. And that was from 2013. And so it's hard to piece that cases back together. So if you can do that, I would appreciate it.
Would the court have any problem if I do that after the hearing?
Nope, after the hearing is totally fine. I just want it for connecting the dots in case. Okay, Ms. Rawls, that is the agreement. And your attorney has handed me, well, I have two documents. One is a plea questionnaire, waiver of rights form, attached theft by employee, trustee, or Bailey. I should have known you put the jury instructions because you're very thorough. And so I could have told the statute right there. So thank you, Mr. Reed. And he has the jury instructions and the other document that shows the offense and what needs to be proven. Do you recognize these documents?
Yes.
Did your attorney thoroughly go over these documents with you?
Yes.
Did he essentially go over them word for word?
Yes.
And so you understand everything on these documents?
Yes.
And with regards to the plea questionnaire, is that your signature on the second page?
Yes.
So your attorney went over with you, state would need to prove your guilt beyond a reasonable doubt, 2 misdemeanor thefts, correct?
Correct.
And he went over with you the maximum possible penalties you face. Is that correct?
Correct.
Now, I also have the deferred judgment conviction document. Some of the terms, the more important terms, were stated on the record. Do you recognize this document?
Yes.
And did your attorney thoroughly go over this with you?
Yes.
Essentially word for word?
Yes.
So you understand everything completely.
I do.
And that is your signature on the last page?
Yes.
And with regards to the important terms, I'm just going to go over them again with you, that if the court accepts this agreement.
Wait, did you catch? That 14 years and 8 months. That's longer than most marriages last. Would you agree to almost 15 years of financial probation just to avoid prison?
That it would run for a period of 14 years and 8 months. Do you understand that?
Yes.
And after today's payment, you would owe $87,850.94. Is that correct?
Correct.
And you're going to make at minimum $500 a month payments, correct?
Correct.
And if they are late, if one of the payments is late, they're due by the 13th of every month. Do you understand that that's enough for the state to ask to revoke the agreement and to sentence you and enter judgment?
Yes.
This is a tightrope walk. One late payment. Even by a day, and Jennifer could lose everything. Imagine living with that hanging over your head for over a decade.
So, if you pay it off early, you can have the agreement go away and not worry about that felony anymore. You understand?
I do.
Do you also understand that within 60 days from today, you must pay $150 to the district attorney's office?
Okay.
If you don't, that's the number one reason I see the district attorney's office asking to have these matters or these revoked and to set you for sentencing. Do you understand?
I do. Do I pay that where I pay my ticket?
No, you pay that at their office.
Okay.
Okay?
And where's that at?
Very important.
Okay.
Very important you do that, and I would do it as quickly as possible.
I get paid Friday, so I'll do that.
All right. So I have that you're pleading guilty to 2 counts of misdemeanor theft and 1 count as charged, theft of a business setting greater than $10,000 but less than $100,000. Is that correct?
Correct.
You're 39 years old. You have 12 years of school. You can read, write. You understand the English language.
Yes.
You are not currently receiving any treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on both of the documents on the first page. Your attorney thoroughly went over those rights with you,
He did.
and you understand them completely?
I do.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
That even concerns deferred judgment of conviction. You understand that?
I do.
Do you understand, or do you need me to go over these rights with you in any more detail?
I do not.
You understand that you're pleading guilty to a felony. If the court accepts the deferred judgment of conviction, this won't be applicable to you if or until the court enters judgment to sentence you. Do you understand that at that time, you would no longer be able to use or possess a firearm for life?
Correct.
You would no longer be able to vote in any election until your civil rights is restored.
Correct.
Those do not apply to the misdemeanor thefts, okay?
Okay.
All right. Do you understand that here, the state would have to prove, with regards to charge, that it has been charged, that count one, theft of a business setting, greater than $10,000, but less than $100,000. Do you understand that state would have to prove on or around and between February 7th, 2023 and July 6th, 2024 in Burnett County, Wisconsin, by virtue of your employment, you having money in your possession greater than 10,000 but not to exceed 100,000, and you retained possession of that money without the owner's consent and with the consent to convert that for your own use. Do you understand that?
I do.
And do you understand the maximum possible penalty if the court enters judgment of a G felony could be up to a $25,000 fine, imprisonment of up to 10 years or both? Do you understand that?
I do.
As to both of the misdemeanor thefts, do you understand for each of the thefts, the state would have to approve, or would have to prove that you had possession of, oh, wrong one, sorry, that you intentionally took and carried away with property of another. You took and carried away that property without the owner's consent. You knew that taking and carrying away that property was without consent, and you took and carried away the property with the intent to permanently deprive the owner of that property. And this is less than $2,500. Do you understand what the state would have to prove?
Yes.
And that's for both counts. Do you understand that?
Yes.
Do you understand the maximum possible penalty for each of those counts could be a fine of up to $10,000 or imprisonment of up to 9 months or both? Do you understand that?
Yes.
Do you understand that this court is not bound by the agreement reached between the parties?
I do.
Said differently, if I thought that there should be something different for us, I can do that in my discretion. Do you understand that?
I do.
Do you also understand I do not have to accept a deferred judgment of conviction?
I do.
Do you still wish to proceed and enter a guilty plea?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Did you review this criminal complaint with your attorney?
Yes.
In particular, there is a section called the probable cause section, and it basically says what happened throughout that time and why you were charged with crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Reed, may the court use the probable cause section of the criminal complaint to find a factual basis?
No objection, Your Honor.
Has anyone made any threats or any promises to you, Ms. Rawls, for you to plead guilty to these crimes?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing.
Yes.
And voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the defense or at the discovery, and has he discussed that with you?
Yes.
Has he discussed with you whether or not you have any defenses or a lack of defenses in this case?
Yes.
Has he discussed with you what could happen if the matter goes to jury?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or your attorney before I proceed?
No, thank you.
Mr. Reed, do you believe that Ms. Rawls is entering her...
So far, the defense is painting Jennifer as cooperative, remorseful, and ready to pay up. But remember, the final call isn't theirs. It's the judges, and judges don't like being played.
plea freely, intelligently, and voluntarily?
Yes, Your Honor.
Do you believe she understands the rights she's giving up and what that means?
Yes, Your Honor.
Do you believe she fully understands the deferred judgment of conviction and how important it is to meet every single provision?
Yes, Your Honor.
Does she understand the ramifications of what could happen if she does not meet every single provision?
Yes, Your Honor.
Any reason to believe she is not competent to enter her plea?
No, Your Honor.
One last time, any questions for the court or your attorney?
No.
As to count one, theft of a business setting greater than $10,000 but less than $100,000, class G felony, how do you wish to plead?
Guilty.
As to count two, which is Now added to this case, misdemeanor theft under $2,500. How do you wish to proceed?
Guilty.
As to count 3, count that was added to this case, misdemeanor theft under $2,500. How do you wish to proceed?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 of those charges. As to counts 2 and 3, judgment will be entered. As to count 1, the court will hear arguments on whether or not to accept. We are in victims' rights compliance.
Yes, Your Honor.
All right, argument, Mr. Schmidt.
Judge, these are always the hardest cases when you have an offender who.
Here's the state's angle. Yes, Jennifer's a first-time offender, but this isn't shoplifting candy bars. It's an $88,000 embezzlement, money skimmed from an employer who trusted her. That betrayal hits harder than the dollar amount.
At age 39 commits their first crime, and it's a really big crime. It's an embezzlement of a large amount of money from an employer that trusts them. The reason she was even in a position like that as a manager of this gas station is because she does have large ability to work and do a good job and get income. The amount of money is very large. Paying that back is a high priority, especially given the number of it. But it's too severe to just do a DJOC, which is why we have the extra convictions there. Those are her first convictions, and that will be a significant consequence to whoever itself, especially given what their convictions for. We really want to incentivize her to pay the money back. That's why we did the DJOC. I think she has high ability to pay in the future. That's why we're willing to do what I would wager is the longest DJOC ever done in the history of our office. We're willing to do that to make this business whole again. Another reason why we even remotely consider doing this is, this isn't just accepting responsibility here with the judge after you've been caught. She accepted responsibility when she was talking with the managers originally when they first sniffed it out. So this is really trying to restore the state of affairs back to where they were while still giving some accountability in terms of the convictions. Like I said, there's really no reason to think alcohol or drugs or gambling or any of the vices we typically see as drivers of criminal behavior here. The only thing the defendant alluded to when she was interviewed by the managers was issues relating to herself.
Fines and other stuff. And that's what I don't understand is $87,000 in change. It's a lot to pay fines and stuff. So, but I'm hearing, at least from you, that there's no underlying issues to be concerned about as gambling or
Nothing like that.
The shopping addict.
And you have to remember, this isn't taking $88,000 out of the till. This is over a very long period of time. Something you commonly see with most people who commit embezzlements is they have no clue how much they took until someone adds it up and shows the receipts later, and they're like, oh my God, I took that much. So it's not uncommon to see this.
But it can't just be for fines and stuff.
I couldn't say. All I can say is it can't be traced to vices.
All right, Mr. Reed, argument and sentencing recommendation, please.
Thank you, Your Honor. I'm asking the court to follow the joint recommendation because I believe under the galleon factors it's appropriate. These are serious. This is a serious situation, Your Honor. It's a G felony. But I believe the public is better protected by Ms. Rawls working to make the victims whole. This is a case where she's worked hard to get the money that she's put into the court's office already. She's made a promise to make these payments. She's worked with prior counsel and current counsel to figure out a way to make the victims whole here. So I think that the community is protected by this. I think this is serious. I believe that incarceration isn't going to help Jennifer, help the public. She can't work to make the victims whole here. So I think under the galleon factors, this joint recommendation is appropriate. Again, these are her first convictions. Her judgment, I think, is appropriate given her past and given her work on this case to work towards making the victim whole. So we're asking the court to follow the joint recommendation because it's appropriate given the factors. Thank you.
All right, thank you. Ms. Rawls, this is your opportunity to provide any statement to the court that you wish. You don't have to, but it's your only opportunity to tell me anything that you think I should know or be aware of as it relates to this matter and to sentencing, okay?
Whoa, silence. This was her chance to plead her case, show remorse, maybe sway the judge, and she passed. Do you think staying quiet was smart or a massive mistake?
I don't have any.
Oh. Again, I don't understand how $87,000 or $88,000 was used to pay for fines and stuff. That's a lot of fines and stuff, even if it's over a course of multiple years, as we have. It's just 1 year. Well, it's February 7th, 2023 to July 6th, 2024. It's a whole lot of fines and stuff. And if you look at that, that's approximately $2,300 each time that was taken, because there were 40 times that have been found that you were taking or that you took money. So I'm just trying to wrap my head around this, because this is a very serious. That's a lot of money over the course of that year and a half. It's a lot of money. I'm not being told that you have any vices, you don't have any addictions such as gambling or alcohol or any drugs. Not heard that you have any shopping addictions, or that there wasn't one huge lump sum and you went and bought a car. Something like that. I'm not hearing anything. That's why I'm having a hard time understanding. And I did read in the information I get that you were concerned about your son and you wanted to prevent him from going to prison. I don't know what he did. I don't know if it's $88,000 worth, but that's a lot. So this is serious, because this is a lot of money taken from your employer. And I know some people would look at this and say, it's a gas station, it's a corporation, they have money, they lose money all the time. It's not like I stole the money from church. It's not like I took the money from my best friend. We've had all of those. But taking money, especially this amount, from a corporation, is still wrong, and it's still a crime.
And here's the judge's bottom line. Restitution first, punishment second. In cases like this, the system cares less about locking someone up and more about making the victim financially whole again. The felony hangs like a sword, but if she pays, it disappears.
And it still hurts. It may not hurt their end book, their year-end book, but it hurts everyone in this room, because with the theft and that amount of money, they have to increase prices on all of their things. So consumers pay. So again, that makes this more serious. When I look at your character and your past criminal record, you don't have one. It sounds like you have a good character for the most part. You wanted to help your son out. You wanted to make sure that you were being a good mom. You were working. But with the theft, it leaves a little bit of concern with credibility and trustworthiness. I don't have anything that says that you are in need of going to prison or even serving time in jail for this. This time. The number one goal in cases like this is restitution, making the victim whole, making sure that they get all of the money back that was taken. So that's why a deferred judgment of conviction is appropriate in this case. And I can see that, because if you're in prison or if you're in jail, you cannot work, you cannot pay this back. In prison, I think they get 15, 20 cents an hour. You'll never pay it. So this is a good plan. And hopefully you're going to be able to make payments above $500 a month, and you can have this felony off of your shoulders, and the victims would be made whole. And in the end, everybody wins, and you still have punishment with the 2 convictions. Because you're 39 years old, and now you're a criminal. Now you have convictions on your record. They can't be hidden, and they're theft. That will continue to follow you, and it will continue to follow you with each and every employment that you engage in. That's unfortunate that you brought this upon yourself. When I look at needing to protect the public, that aspect, I don't need to protect this victim anymore. You're no longer employed there. I just need to protect this victim in looking at getting that restitution back. I can't protect your other employers because I don't know where you work and I don't know where you're going to work. So as of today, I can't do that or look at that. This is a crime, but it's not a burglary. It is a theft. It's not a burglary, which is violent. It's not substantial battery. It's not engaging in disorderly conduct when you are very intoxicated from substances or alcohol. And I've been on enough cases like this to know that what Mr. Schmidt stated is accurate and true. When a person engages in this type of theft,